This is going to be a brief overview of the United States Constitution. Obviously, if you take a constitutional law course, you'll get much more detail than I can give you here. In the summer of 1787, delegates from the 13 states convened in Philadelphia and drafted a remarkable blueprint for self-government, the Constitution of the United States. Article 6, Section 2 of the Constitution provides that the Constitution shall be the supreme law of the land. The Constitution set up a system of checks and balances. And the way they did this, the way the document did this, was by setting up three distinct parts of government. One was to set up a strong executive branch, another was to set up a representative legislature, and the third was to establish a federal judiciary. The main body of the Constitution establishes, defines, and limits the power of the three branches of the federal government that I just referred to. Number one, that of the legislature to make statutory laws, that of the executive branch to enforce the laws, and third, that of the judiciary to interpret the laws. So again, the legislature is to make the laws, the executive branch is to enforce the laws, and the judiciary's responsibility is to interpret the laws. Following the main body of the Constitution, and remember, in the appendix of your intro text is the full text of the Constitution, and we all should be familiar with the Constitution. Following the main body are 26 amendments, and the first 10 are known as the Bill of Rights. The absence originally of a Bill of Rights turned out to be an obstacle to the Constitution's ratification by the states. It would take 4 more years of intense debate before the new government's form would be resolved. Recently freed from the despotic English monarchy, the American people wanted strong guarantees that the new government would provide the freedoms that they had not experienced in England, thus the Bill of Rights. Thomas Jefferson argued that a Bill of Rights is what the people are entitled to against every government on earth, general or particular, and what no just government should refuse. The Bill of Rights, inspired by Jefferson and drafted by James Madison, were adopted in 1791 and also became the law of the land. We'll discuss the Bill of Rights in the 14th Amendment in the Bill of Rights slideshow. Note that the Bill of Rights apply only to the federal government, but the 14th Amendment provides, "Nor shall any state deprive any person of life, liberty, or property without due process of law." The U.S. Supreme Court has held that the first 10 amendments apply to the states because of the 14th Amendment's due process clause. Now, it's important. The 14th Amendment made the first 10 amendments relevant to the states. Our system of government is based on a dual court system. At the time the Constitution was drafted, there was so much distrust between the states due to the differences in their size, population, and economies that the Constitution was framed to limit the power of the federal government while preserving the autonomy of each individual state's government. Each state, therefore, has its own constitution, which is the supreme law of that state. It's still subordinate to the federal Constitution, and it's similar to the federal Constitution, but it's usually more detailed because it covers matters specific to the state, such as financing public works and how the local government should be organized. Article 6, Section 2 of the Constitution provides that the Constitution shall be the supreme law of the land, and the Supreme Court has held that this means that neither state or federal legislatures could enact laws in violation of the Constitution. And since the Supreme Court interprets the Constitution, the Supreme Court can exercise significant authority over state action. And remember, the role of the courts then, again, is to interpret the laws as well as to determine whether or not a law is violative of the Constitution. The doctrine of preemption is the doctrine that governs the conflict between the federal and state statutes. When a state statute, or when a federal statute overlaps or is in conflict with a state statute, the federal statute will take preference and prevail, even to the point of sometimes invalidating the state statute completely. The most important phrase in the Constitution for the operation of our legal system is the Due Process Clause of the 5th and the 14th Amendments. The Fifth Amendment provides that no person shall be deprived of life, liberty, or property without due process of law. And because this only applied to the federal government, the 14th Amendment was ratified in 1868, and it included the language, "Nor shall any state deprive any person of life, liberty, or property without due process of law." In this way, actions by state officials, legislators, and courts became federal constitutional issues if denial of due process is alleged. Well, what is due process? Due process is hard to sometimes understand. It's been defined as requiring fundamental fairness in judicial processes and prohibiting legislation that is unreasonable, arbitrary, or capricious. Obviously, there are subjective concepts as fairness and reasonableness are in the eyes of the beholder. But as long as the court has the last word, then what the court says is fair, and what the court says is reasonable. And due process is therefore a guarantee of the 5th and 14th Amendments that provides that law administered through courts of justice is equally applied to all under established rules that do not violate fundamental principles of fairness. Now, there's two types of due process: procedural and substantive due process. Procedural due process is the due process that is concerned with the fairness of notice and hearing provided to a person by the government. Notice in law represents a time requirement of notification of the opposing party. Under procedural due process, the fairness of legal procedure requires that a party must be given sufficient notice to prepare a response for legal action. And hearing is the presentation of evidence and argument before a tribunal. And under procedural due process, the hearing, usually the trial, must be fair and even-handed. And most of the elements of a fair hearing have been established by both custom and precedent. Substantive due process, on the other hand, is a theory that emphasizes judging the content of a law by a subjective standard of fundamental fairness, and that the government may not act arbitrarily or capriciously in making, interpreting, or enforcing the law. And that was what the issue was in Papachristo v. Jacksonville. The 14th Amendment of the Constitution also prohibits its states from denying any person within its jurisdiction the equal protection of the laws. This language was designed originally to protect former slaves from discriminatory treatment after the Civil War. Today, however, it's been expanded to invalidate all laws and procedures that unreasonably discriminate. It's used today for cases related to racial discrimination, sex discrimination, age discrimination, disability laws, etc. And the equal protection of laws then is basically a constitutional guarantee that every state must give equal protection to every person who is similarly situated or to every person who are members of the same class. Article 3 of the Constitution vests judicial power in the Supreme Court and in such inferior courts as the Congress may time to time ordain and establish. Section 2 of Article 3 refers to judicial power over cases and controversies. Well, what are cases and controversies? Well, the Supreme Court has interpreted that to limit access to the federal courts, and one of the ways they do that is through the issue of standing. Standing basically means that you have the standing to sue. It's a person's right to bring a lawsuit because he or she is directly affected by the issues presented and have a stake in the outcome of the suit. So, for instance, if I don't have any children in the school district in Collier County, I cannot sue the Collier County School Board. If you have a child in the school board, in the school district, you would have standing to sue. So you have to have some involvement of the issues presented and really be concerned with the outcome. Controversies, the court has also interpreted to mean actual disputes between real parties. Not every disagreement or annoyance or rebuke is a legal matter. And the court refuses to hear issues that maybe are hypothetical issues and aren't real issues at all. And that's the cases and controversies. Full faith and credit clause of the Constitution is found in Article 4. Article 4 states that full faith and credit shall be given to each state to the public acts, records, and judicial proceedings of every other state. Basically, this means that the courts of every state must recognize the laws and the validity of judicial orders of other states. So, for instance, if you're divorced in Florida, New York needs to recognize that divorce. If you have custody of your children in Nevada, then New Hampshire needs to recognize those laws. And of course, this brings up a lot of issues lately around the issue of gay marriage in Massachusetts, that Massachusetts has recently legalized marriage between gay and lesbian couples. And the issue that is being addressed already around the country is whether or not every state has to give full faith and credit to that law. The power and authority of a court in any particular dispute are based on jurisdiction. When we talk about subject matter jurisdiction, which refers to the kinds of disputes a court has the authority to decide. And we have two types of courts: courts of general jurisdiction and courts of limited jurisdiction. Courts of general jurisdiction have the authority to hear a wide variety of cases and apply the full range of judicial remedies and relief. Major trial courts have general jurisdiction. Limited jurisdiction courts, on the other hand, restrict the court's authority to decide only certain kinds of cases. So, for instance, a probate court can only decide cases related to a decedent's estate and can't decide divorce cases. Small claims municipal courts are other examples of limited courts of jurisdiction. The Constitution also gives authority to federal courts to hear cases, and there's two categories of cases that federal courts have subject matter jurisdiction over. One are federal question cases, and the Constitution provides that federal courts have jurisdiction over any case that arises under the Constitution, the laws, and treaties of the United States. A case may directly raise a constitutional issue, or it may arise under a federal statute, and these are federal question cases. Diversity of citizenship cases, on the other hand, are cases where the parties to the case do not live in the same state. So, for instance, a plaintiff of Texas is suing a defendant in New Hampshire, and you may elect to sue in the state court, or you may elect to sue in a U.S. district court. And the differences in state citizenship are referred to as diversity of citizenship, and jurisdiction is based on the status of the parties without regard to the subject matter. And diversity cases additionally require that the amount in controversy exceeds $75,000. Well, I said in the beginning, this is a very broad overview of the U.S. Constitution. Again, all of us as citizens of the United States should be familiar with the Constitution, and you should really take the time to read it. We will cover more later on, and hopefully this was helpful, and I will see you next time.